how much of my premarital retirement will I keep in divorce? Hi, I'm Bill Farias, founder of Farias Family Law. This comes up very often. We just spoke to someone about a week ago, and this is the main issue. She's in a short-term marriage, has a ton of premarital retirement money, and she's afraid that she's going to lose some of that in her divorce. And so the way to think about this is that, first of all, the only way to truly optimize protection of your premarital assets is with a prenup, right? A prenuptial agreement, a contract where you can essentially exclude anything you want, just about generally. There are some limits, but you can exclude what you want from the marital pot in the event that you get divorced. So if you don't have a prenup, then the courts have a ton of discretion. And in my experience, the key factors are, number one, length of the marriage, and connected to that, length of the parties' economic partnership. And what I mean by that is, let's say the marriage is only 1 year, right? But the parties have been a financial unit, living together, sharing expenses, commingling their respective income and assets for a long period of time, say a decade. Say the parties have only married for 1 year, but they've been together as a financial unit for 10 years. A judge is more likely under those circumstances to consider premarital assets. And so this factor, length of the marriage, I would say also has sort of a sub-component to it of the length of the financial relationship. And again, this is judge's discretion. A judge does not have to consider that time before the marriage, but may do so. And so how long were the parties living together? How long were they a financial unit? How long were they married? And that is a key factor, I would say the key factor in determining whether premarital retirement assets are included, in the sense that the longer the marriage, the longer the parties' financial relationship, the more likely it is that a judge will include premarital retirement. So generally, in most cases where it's a shorter marriage, even intermediate length marriage, in my experience, judges have tended to include only the marital portion of retirement. In longer marriages, 20 plus years, it is more likely that a judge will include all of the retirement in the pot. That depends on the other factors, but looking at this issue in a vacuum, that's how it tends to go. So the answer is, the longer the marriage, the longer the economic partnership, the more likely it is that some or all of the premarital retirement can be included in the marital pot. If you have any other questions, you can call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel and share it with anyone you think might benefit from it. And you can also find us on social media at Farias Family Law. Thank you. Have a good day.